Whenever you're ready, Counselor.
May it please the court, my name is Rebecca Barnes. This is my co-counsel, May Hennessy, and we represent the respondent, Marlowe Motors Incorporated, in the suit brought by Mr. Omar Little, which was previously partially remanded by the 14th Circuit. Today, the court should reconsider the question of whether the state of Colvin has general personal jurisdiction over Marlowe Motors Incorporated. First, I will demonstrate that Marlowe Motors Incorporated did not consent, nor impliedly nor explicitly, by registering to do business in the state of Colvin. Secondly, under the Daimler test and the international shoe test established by this court previously, I will establish that Marlowe Motors Incorporated was neither essentially at home, nor did it have sufficient minimum contacts within the state of Colvin for Colvin to exercise its jurisdiction in this case. First, the Colvin court cannot exercise its jurisdiction over Marlowe Motors Incorporated because Marlowe Motors did not give consent to its authority.
But didn't they register within Colvin?
Yes, and that was a mandatory state statute that required compliance. Title VII of the Colvin Code annotated specifically says that any business intending to do any kind of transaction within the state of Colvin needs to register there. This statute, however, fails to recognize or fails to evaluate the quality, frequency, and nature of those transactions, and therefore I demonstrate that there is no substantial connection between the business registration in Colvin and Marlowe Motors Incorporated's presence there. If you may, their presence in the state of Colvin was merely symbolic. It was not significant. And to buttress my argument, I do cite Goodyear versus Brown, in which the court used the doctrine of purposeful availment to evaluate whether a corporation's presence within the state was significant or symbolic. And under the doctrine of purposeful availment, a corporation purposefully avails itself to a state's authority when it, for example, targets its marketing campaigns to state residents, opens branch offices there, or sends employees there. As we've seen in the facts in the record, Marlowe Motors Incorporated does not fulfill any of the requirements under the doctrine of purposeful availment. Marlowe Motors did launch an international campaign in which it marketed to countries all around the world and sent executives on interviews, both nationally and internationally. So if any Colvin residents saw the advertisements posted by Marlowe Motors, it was incidental to the widespread nature of that campaign. Other than that, Marlowe Motors did not have any branch offices in the state of Colvin, nor did it send employees there, nor did it hire any employees that were Colvin residents.
But didn't it have a registered agent in the state that they availed to be able to receive any type of summons or complaint in the state of Colvin?
So yes, there was a registered agent that was designated to receive the service of process. However, once again, that was not an explicit consent to Colvin's authority. This was merely compliance with a mandatory state statute.
But couldn't it be seen to an ordinary consumer that's having an issue with the company that they could bring a suit in that state because they have a registered agent?
Well, that's very understandable. It would set a concerning precedent because given the nature of corporations today, there are many states that have consent statutes such as this. So the consent-based theory could effectively open corporations to litigation in any state where they've merely had a solo occurrence of one sale and had to register as a business in that state to do that one sale.
Right, but aren't companies put on notice of that and have been put on notice of that since 1917? PA fire insurance is still good law.
PA fire insurance was based off of a corporation that had established an agent to conduct a variety of transactions, and there were more substantial connections between the corporation and the state in that case than there are in this case. On a policy level, the consent-based theory sets a precedent that it incentivizes plaintiffs to forum shop. So, in other words, they search for venues that are most convenient to them, even if the corporation's presence within that venue did not give rise to the litigation being sued upon.
But couldn't the flip be said for your client as well, that you're venue shopping and you're trying to inconvenience a plaintiff who might not have the same means as something like a big worldwide company like your client, where you can say, oh, well, I consented to this because I wanted to do business in your state, but I don't want to be sued in your state. So I'd much rather go somewhere where it's more effective for my attorneys, so I don't have to pay them such attorney's fees to travel to where you are.
Well, I'm very sympathetic to the burden of Mr. Little's case, and given his personal injuries, this is quite burdensome for him. There are several forums in which it would be appropriate to bring this kind of suit. Mr. Little sought out Marlowe Motor Incorporated's products. So whether he saw an advertisement of ours or not, he was going to get himself an autonomous vehicle. In this case, he purchased the vehicle involved in the accident in California, drove it back to his state of Colvin, where he is a resident, and then subsequently drove it to the state of Icaro, where he got intoxicated, fell asleep behind the wheel, and had an accident in that state. Under the personal jurisdiction requirements, there are several other forms that would be appropriate given where the accident occurred, where the product was purchased, and furthermore, under Daimler, where Marlowe Motors Incorporated is incorporated and where they have their principal place of business, which I will get to in my second argument. So while the petitioner argues that Marlowe Motors is trying to shirk their responsibilities to Mr. Little, I push back and say that it is simply not appropriate to bring this suit within the state of Colvin, and their jurisdiction should be reevaluated under the doctrine of purposeful availment. And an extension of that Marlowe Motors Incorporated's business registration within the state of Colvin did not give rise to the litigation being sued upon for the reasons that I just cited. Nothing occurred in the state of Colvin other than the fact that Mr. Omar Little lives there and finds it most convenient to bring this suit there.
Well, besides just registering there, they did have this ongoing multiple year-long relationship with Mr. Little. He donated to them, I believe. He's purchased other vehicles from them in the past. Shouldn't that give rise to an awareness that they could be called to court here?
Well, once again, I believe that this court had previously said during the petitioner's arguments that it's not Marlowe Motors Incorporated's duty to follow where their consumers are state residents. So the fact that their solicitation of funding had an international aspect to it, and we were, once again, sending executives all over the world to solicit funding. Marlowe Motors does not necessarily keep track of who is giving funds from where, from which states. And once again, there's no connection between Marlowe Motors' registration in Colvin and that particular solicitation of funds from Mr. Little. He, of his own volition, chose to give funds because he is not a normal consumer. He is an avid follower of autonomous vehicles, and he wanted to support the cutting-edge nature of this research. Secondly, I would like to say that the Colvin court does not have jurisdiction over Marlowe Motors Incorporated under the Daimler test, which holds that a corporation subjects itself to the jurisdiction of a state if it is essentially at home within that state. The Daimler court, this court, previously established that a corporation is essentially at home if it is either incorporated within a state or if it has its principal place of business there, or both.
But doesn't Daimler also confirm that consent is an alternative basis for a court to exercise general jurisdiction over an out-of-state dependent?
Well, yes, but I, in my first argument, argue that Marlowe Motors did not consent to this jurisdiction. So in the alternative, I was going to argue that under the essentially at home standard, Marlowe Motors Incorporated does not fulfill the other branch of the Daimler test, because Marlowe Motors has been incorporated in Delaware for the last 20 years, and its principal place of business and headquarters are located in California, which is the state to which Mr. Little traveled to purchase the model Herc vehicle which was involved in this accident. Finally, Marlowe Motors Incorporated does not fulfill the minimum contacts requirement established by International Shoe Company v. Washington. In this case, it was established that for jurisdiction to be exercised over a corporation, it must have certain minimum contacts with the forum state so as not to offend notions of fair play and substantial justice. For there to be minimum contacts between a corporation and a state, the presence of the corporation within the forum must be not only continuous and systematic, but also give rise to the litigation being sued upon.
Isn't maintaining an agent in the state continuous and systematic? They could have discontinued that agent.
Well, so under the International Shoe Company standard, continuous and systematic contact was evaluated according to that corporation's employment plan. It was both continuous because it was over a period of several years, and systematic because they had an entire strategy set up to hire in-state residents so that they could more effectively canvass orders and solicit buyers within that state. Therefore, it was systematic, and then it also gave rise to the litigation being sued upon because the question in that case had to do with contribution or non-contribution to the state's unemployment fund. In this case, Marlowe Motors Incorporated has no such systematic nor continuous contact with the state of Colvin.
Right, but looking at some of the circuit split cases, we have the Knowlton case, for example, which completely says whether or not these activities are arising out of minimum contacts, a business registration and a registered agent is enough to have suit brought in that court.
Well, once again, when I addressed that Marlowe Motors Incorporated did not consent, I meant that compliance with a mandatory state statute does not necessarily constitute implied consent because it's not freely given. And in a case where it's not freely given, then that business registration needs to be accompanied by those business contacts so as to establish a more significant corporate presence within that state, not just having a symbolic one. Given Mr. Little's efforts to seek Marlowe Motors outside of the state of Colvin, I think that Marlowe Motors Incorporated's presence within the state of Colvin is neither has minimum contacts with this case, nor did it give rise to the harm that Mr. Little suffered. Therefore, in the totality of the circumstances, the contacts between Colvin and Marlowe Motors are so minimal that it's unjustifiable to have the state of Colvin exercise its authority here.
But didn't Marlowe Motors also have continuous marketing campaigns going to residents of the state of Colvin? I mean, it was part of the national worldwide campaign, but the fact is that these residents were specifically receiving marketing for these vehicles.
So Marlowe Motors Incorporated wasn't doing anything to target Colvin residents. If any Colvin residents saw the advertisements, it was incidental to the international nature of that campaign. It was not done specifically to advertise to Colvin residents. The example that was coming out of International Shoe Company was that the corporation in International Shoe was specifically hiring in-state residents, as I mentioned before. Marlowe Motors Incorporated does not hire according to state residents. They target students and members of top companies around the world to
Is
hire.
their agent an employee?
I'm not sure if the agent is the employee, but we employed an agent to register as a business in the state of Colvin, but I'm not sure of the state residency of that individual. I'll have to double check. But in any case, under the minimum contact standard, Marlowe Motors was not hiring according to state residency, and it was not systematically targeting Colvin residents, neither as consumers nor as employees. Instead, they sought out cutting-edge talent from around the world according to their capabilities. If I may conclude, the Colvin court should not have authority over this suit because Marlowe Motors Incorporated did not consent, neither impliedly nor explicitly, when it registered to do business under the Colvin statute. And secondly, Marlowe Motors Incorporated does not fulfill the essentially at home standard established in Daimler, nor the minimum contacts requirements established in International Shoe Co. My co-counsel will now address the products liability issue.
Thank you, Counselor.